Hello, everyone, and welcome. We will get started in just a moment. All right. Hello, everyone, and welcome or welcome back. We are in the session now, Marketing Sense, ensuring your marketing is ethics compliant. This session has been sponsored by Clio, so make sure to pay them a visit to thank them for helping you get some ethics credit. My name is Bree Vantil. I am still the Director of Education for Alt Legal, and still, I'm sorry to tell you, still your Master of Ceremonies. You're still stuck with me for the next 2 more days. But I am here to make your conference experience amazing and wonderful, so please let me know how I can do that. And as a reminder, if you have any feedback for us, if you would put that in the feedback tab of the chat, I would really appreciate that. As a reminder, the final reminder for today, don't be a jerk. I don't expect that you will ever be jerks, but just don't do it. Okay. All right, then. So I do want to tell you that we are offering ethics CLE credit for this session through the state of California. For those who are in live attendance only, if you are watching this via recording, you're still going to learn a ton, but we can't help you get any credit for it. Sorry about that. I do need you to be present for the entire 70 minute presentation. And when I say the code, I want you to write it down so that you can put it in the survey and submit the survey along with your feedback about the session, and then you'll get a certificate of attendance. So we're still not a law firm. We're still a legal tech company, so we're not providing you with any legal advice. And Mike probably has really, really great things to say, but they're not necessarily the views of Alt Legal. So just so you know, we're not the same people. All right. Please use the chat to talk amongst yourselves, but if you have any questions for Mike, go ahead and put those in the chat. But please try to start that with the word question so that we can easily distinguish those from just chit-chatting with one another. All right. I am pleased to welcome our speaker, Michael McCabe. He is the managing partner at McCabe Ali, a firm dedicated to helping you get out of ethics trouble. I don't know if I'm supposed to say it that way, but come on, that's what happens. Back in the day, Mike served as a patent attorney at notable firms like McDermott, Will, and Emery. Prior to that, he was a NASA engineer. So, dude's basically a rocket scientist. All right, strap in for this. Here we go. That's all you.
Hi. Thank you so much, Bree. I really appreciate that very kind introduction. And thank you all for attending our section of the program today. In trying to present on the ethics issues that arise in the context of marketing and solicitation, what I've really come to discover is that the topic itself almost lends itself to a historical perspective that requires some historical analysis of how we practice law, how we have practiced law in the past, and how we are practicing law today. One of the fascinating things that you will see as we discuss the history of some of these advertising and marketing rules is how they have fundamentally changed over the course of years based upon changes in society, changes in technology, and changes in expectations about where lawyers fit within the grand scheme of professionals. Are we really professionals, or are we tradespeople who are just out there for making money? And part of our discussion is really about a fundamental bashing of two competing issues that really come to head in the forefront of advertising and marketing. And that is, what's the bar's purpose when it's regulating lawyers? The bar tells tells us that the bar is there to regulate lawyers for mainly one specific purpose, and that's to protect the public. The flip side of the public protection concerns that the bar has is the concern that the laws of professional conduct are really about protecting the legal profession itself from other sources of competition. And those two themes of the bar, on the one hand, being our parents or great-grandparents who are going to look after us and make sure that we do things a certain kind of way, is butting up against the issues like the First Amendment and freedom of competition, as well as overregulation and overzealous regulation. So what we're going to talk about this evening are a little bit of history of where does the U.S. Patent and Trademark Office fit into the entire regulatory scheme where it comes to the ethics rules, and in particular advertising and marketing ethics. We'll discuss some of the historical background of regulation of legal advertising and solicitation, how that has changed over the years, and what the current standards are in place. We're also going to take our discussion to another level that isn't just straightforward advertising and marketing rules, but really looks at how the advertising and marketing rules come into play with how we are delivering legal services to the public in the year 2021. And some of these topics deal with matchmakers, we'll call them, and platforms. We'll be talking about those types of legal delivery services. We're also going to talk about the unauthorized practice of law, as well as how foreign associates who play a big role in the delivery of legal services in the United States, particularly with respect to the intellectual property field, where do they fit in? And how does the regulation of lawyers impact our dealings when we deal with foreign associates who assist us in protecting intellectual property rights for foreign clients? So let's first take a look at where does the Patent Office fit into this? Because when we talk about the bar, everyone thinks about the state bar. You're a member, you become a lawyer, you become a member of the state bar, and as part of your membership, you are bound by rules that are the ethical rules that your state has adopted, whether it's California, New York, whichever. Every state has its code of professional conduct, and every lawyer that is admitted in that state or practices in that state is required to conduct themselves in accordance with the state bar rules of professional conduct. State, and I'll include the District of Columbia as well, which is a major jurisdiction. The Patent and Trademark Office has its own bar, and it has its own set of ethics rules and professional responsibility rules that bind lawyers who practice before the U.S. Patent and Trademark Office. So you as a lawyer may be admitted, I'm admitted in Maryland and DC and Virginia, so I am bound by the ethics rules of all of those jurisdictions. But I also am a registered patent attorney, and based upon my registration to the Patent Office, I am also bound by the U.S. Patent and Trademark Office's rules and regulations, which include the rules of professional conduct that the USPTO has adopted over the years to sort of mimic what the states have done in the relative state schemes and how the states regulate their individuals. So the USPTO is kind of like a grand poobah of bars that isn't necessarily tied in with your state law license. In fact, 25% of registered patent practitioners are patent agents who aren't admitted to a bar in any state at all. The only regulators that are really responsible for regulating their conduct is the USPTO. When you get to patent attorneys like myself and maybe many of you, we're regulated both by the state bars in which we're members of, as well as the USPTO's rules of professional conduct. If you are practicing in trademark law and you are not a member of the patent bar, that doesn't mean that the USPTO's regulations on professional conduct don't apply to you. They absolutely apply to trademark lawyers, non-patent practitioners who practice in trademark and other non-patent matters, but mostly trademark, before the U.S. Patent and Trademark Office. All of those state licensed attorneys are allowed to practice in trademark law at the USPTO because of their state bar membership. That entitles them to get in the door to practice before the trademark office, before the PTO in trademark matters. But when it comes down to the regulation side, those practitioners are governed both by their own state bar's code of conduct as well as the USPTO's codes of conduct. So the point is, anyone who's practicing in IP law needs to understand the various schemes of rules that govern their conduct. The USPTO's rules are very important because the USPTO director has the authority to exclude, meaning disbar, or suspend, meaning to basically lose your law license for a period of time. Any person, agent, or attorney who practices before the office who doesn't comply with the regulations that the PTO establishes, which those regulations are, in fact, the USPTO's version of the rules of professional conduct that themselves are modeled after various state bar ethics rules. So the USPTO plays its own independent role in regulating attorney conduct. I could not get in trouble with any of my state bars, but if I do something incorrect or inappropriate before the USPTO, I could not only lose my right to practice before the USPTO, which would be horrible. I would lose my ability to practice in trademark law. I would lose my ability to practice in ethics before the USPTO, and I would lose my right to practice in patent matters before the USPTO. But so not only does a bad result in the PTO hurt you from practicing law in the PTO, but every state in the United States respects the USPTO's disciplinary decisions and gives them reciprocal treatment. So if you get disbarred from the U.S. Patent and Trademark Office and you're a member of, let's say, the New York Bar, even though the New York Bar didn't do anything to cause your disbarment from the USPTO, the New York Bar will look at you as a disbarred lawyer and say, well, you've been disbarred in the USPTO. We have our own rules here that say if you get disbarred in another jurisdiction, you get disbarred from here too. And so from that, you can see that anyone who gets suspended or significantly disciplined by the USPTO, they can find themselves in a world of trouble where they could end up not being allowed to practice law in any of their jurisdictions solely based upon the USPTO's rules. So let's talk about this history of advertising and where has it come from and why has it changed over the years. So I'm going to go back a little bit in time now to the 1800s. I wasn't really expecting to do a history lesson today, but I think this type of topic lends itself to a little bit of historical background. And I'm going to go back into the 1800s. Back in the late 1800s, lawyers actually advertised. Wasn't that big of a deal for lawyers to advertise. And they typically would advertise, if they would advertise at all, they would typically advertise in the local newspaper. Was no television back then. There was no other forms really of media other than the radio. And so most advertisements of lawyers were print advertisements that ended up being like sort of little business card-like ads that would wind up in newspapers of general circulation. Well, come around the early 1900s, some people at the bar really didn't think it was appropriate for lawyers to be advertising at all. They thought that lawyer advertising was a bit unseemly, and there was a significant body of attorney regulators who viewed lawyer advertising as inherently dishonest, disreputable, not lawyerly, and inherently misleading. And so the reaction initially to this sort of attitude that the bar developed, which came about in the early part of the 1900s, was a code of conduct was developed around 1908. Many of the states adopted as their own early versions of lawyer codes of professional conduct. In that early version of the rules of conduct, the bar basically said no advertising at all. None. Nothing. It's just not appropriate. We don't do advertising. And for almost 75 years, that was essentially the standard that most bars around the United States adopted, was the no attorney advertising rule. That changed in the 1970s as a result of two attorneys in Arizona who had decided to open up a law practice, right? And they did something that was very unusual at the time. They put an ad in the newspaper. And here is the ad that they put. This was an advertisement that just ran in the Arizona Republic, a general circulation newspaper. It was said, "Do you need a lawyer? Legal services at very reasonable fees." And the advertisement offered certain low-cost fixed fee representations for certain legal tasks, essentially simple divorce, simple bankruptcies, simple name changes, simple and fixed fee. One would think by 2021 standards that this is a kind of a harmless little ad, and how could anyone be upset by something like that? Well, you look at that advertisement against what the rules were in place at that point in time. The Arizona bar had its own rule that it was its codification of the 1908 rule that was basically you can't publicize yourself at all, anywhere, and you can't allow anybody else to do it for you. You can't do it in newspapers, magazines, radio, TV, display advertisements, city directories, telephone directories, no commercial publicity at all, none. So these two lawyers actually challenged that rule. They developed their reduced cost model for providing legal services to the public, but they ran into a problem that because they weren't allowed to advertise, no one knew about their service, right? So they realized that this is going to be a problem for them to get the message out to the world that they're offering these fixed fee legal services. So they placed an ad in the newspaper in direct violation of that Arizona law. This advertisement that they posted literally would violate the Arizona rule, and it would literally violate most of the rules that were in place in that time period in the mid-1970s. In fact, the Arizona bar took this so seriously that they even recommended a 6-month suspension for the two lawyers who placed this, I'd say, rather innocuous ad in the newspaper. The bar ultimately knocked that proposed suspension down to something like a week or maybe a month, but it was still a pretty significant punishment for running an advertisement in the newspaper. The case went to the Supreme Court of the United States, and in a case called Bates v. Arizona, the Supreme Court of the United States for the first time held that blanket restrictions on lawyer advertising violate the First Amendment. The ad ban didn't have a substantial justifying need. The ad ban gave an advantage to established lawyers. The Supreme Court said that it's okay for the bar to regulate content in some respects, but a blanket prohibition on all content was unconstitutional. They opened the door, though, for several areas of regulation that took hold and took shape in the ethics rules on advertising for the next several decades. One was that the court said, well, you can still regulate you can regulate for content that's false or misleading advertising. Okay, so lawyers can advertise, but they can't falsely advertise or misleadingly advertise. The court also opened the door to what we later became known as advertising labor rules, where the court said, we don't foreclose the possibility that there may be some limited supplementation that the bars could require, in essence, like warning labels that you would see on certain advertisements, that some sort of a disclaimer or a warning or something that should be added to protect the public. The Supreme Court didn't decide whether that was okay or not okay, or that they just raised that as a possible area in which the bar could actually regulate that kind of conduct. And so in a later Supreme Court case that also dealt with this, what is called the commercial speech doctrine, the Supreme Court again took interest in what is the legal standard for assessing the constitutionality of regulation on commercial speech. In the Central Hudson versus Public Service Commission of New York case, that didn't deal with lawyers or advertising, but it did deal with a particular public service announcement by the state of New York, which was promoting a certain type of electricity or a certain type of energy usage. And that was against a violation of New York law. Went to the Supreme Court and they established a 4-part test, which was, is the expression protected by the First Amendment because it concerns a lawful activity and is not misleading? Check 1. Is the asserted government interest substantial? That's the second check. Does the regulation advance an important government interest? That's a third check. And then the final check that was really important, is the regulation more extensive than what is necessary to for the government to meet its substantial interest? Since the Bates case evolved, after the Bates case, but before the internet, what happened was a literal explosion in lawyer advertising. Started with those types of technologies that were around in the late 1970s and then the 80s, and then the 90s, and even in the 2000s, even continuing on till today. But where did you see advertising going? Well, it went everywhere. TV advertisements, buses became ginormous mobile billboards. Billboards became ginormous lawyer advertising sites. And if you ever drive around in the state of Florida, they must have a lot of lawyer needs in the state of Florida, because I was just down there and I probably passed 500 lawyer billboard signs in about a 10-mile area outside of Miami. So big legal need for lawyers down in the South Florida area, evidently. And of course, there was all sorts of advertisements in all sorts of forms, radio, TV, etc. Now, what happened after the Bates decision? That was 1977. What did the states do after that? Well, the bar itself became more organized, and they kind of tossed out the 1908 version of the rules. They decided, well, it's now the 1980s. And in the post-Watergate era, there was a real renewed interest in professional regulation of lawyers, but also keeping in mind other developments like the Bates decision. And so what the American Bar Association did in the mid-1980s is developed a code of professional conduct that was what became the modern day equivalent of what is called the ABA Model Rules of Professional Conduct. Those rules are still applicable today in most jurisdictions. And they take a very interesting approach to lawyer advertising post Bates case. And where the bar has now broken down the evolution of attorney advertisement. It really focuses on some of the exceptions that were pointed out in the Bates decision. You recall that Bates spoke about, well, there's no problem with regulating false or misleading advertisements. And so lawyers can advertise, provided that their advertising is not false or misleading. And a second aspect of lawyer advertising is that lawyers cannot give anything of value to a person for recommending a lawyer's services. There's an exception that the courts and the regulators wrote into their ethics rules, allowing for advertising costs. And there's an exception for lawyers who provide non-exclusive reciprocal referrals to other lawyers. But for the most part, the rules are that you cannot give a lay person or a client or a non-attorney cannot give anything of value to a person for recommending the lawyer's services. A lawyer may share fees with other lawyers, however, and so if you get a referral from another attorney, you could share legal fees with that other attorney with the client's consent, provided that the client consents to the relationship and that the total fee is reasonable. In addition to the no false or misleading advertisements and no giving anything of value, the rules that were adopted by the ABA in the mid-1980s included other specifics. They said, well, the ads should include the name and address of an office space for the lawyer or law firm that's responsible for the content. The ABA also looked at how lawyers not just advertise for business, but also how they solicit clients for business. And solicitation is something very different than advertising. The solicitation involves a real direct contact, a targeted communication that it's directed to a specific person where you are directly offering that person legal services. And the rules said that, well, we're going to draw a line about how targeted you can be. You can send a letter to somebody because that's not an in-person or live telephone conversation. However, for you to do an in-person solicitation or a live telephone solicitation for someone that you believe needs legal services, that is very limited. You were only allowed to do that if the person needing the legal services was another lawyer or a family friend or someone that's a family member or family friend, or someone with whom you have an existing prior client relationship, a former client relationship with. The ABA developed rules that also said that solicitation isn't appropriate if it allows any form of coercion, duress, or harassment. And it's also not permitted if the lawyer knows that the client does not wish to be solicited. And if you think about these early solicitation rules, what the law was really getting at was that there was some real concerns about so-called runners and cappers. These are people that would be so-called ambulance chasers. They would literally follow the ambulance to the emergency room. They'd sign up clients in the ER. They would refer those clients to lawyers. They would take a piece of the action. And that was very much a problem that the legal industry had, that they felt like this is really taking advantage of people who are in a bad situation, that we've got to have limits that prevent this kind of targeted, direct solicitations of prospective clients, particularly when they're in a situation where they aren't going to be thinking at their level best. The ABA also developed rules picking up on the U.S. Supreme Court's idea in the Bates case that you could put disclaimers in advertising, and you might want to require a disclaimer in advertising. And so what many of the bars did was they created rules that required disclosures and disclaimers to be included in any form of advertising material. And the way the rule was written, because this was written in the mid-1980s and there was no internet or anything like that, the disclaimers of advertising were supposed to be on the outside of the envelope or at the beginning and ending of a recorded or electronic communication. So it was really thinking about the types of advertising that's done. It could be a newspaper advertisement. It could be a direct letter that is sent to a prospective client, but it needed to have advertising material in some sort of font that stood out from the rest of the text around it. There were also regulations that said, well, you can't state or imply that you're certified as a specialist in a particular field unless you really are. And the only real, at the time that these rules were promulgated in the mid-1980s, the real recognized specialties were patent law and admiralty law. And the ABA understood that these were real specialized practice areas. And so someone could hold themselves out as a patent attorney or a proctor in admiralty, for example, and that would be okay. Someone couldn't hold themselves out, though, as a specialist or being a certified specialist in a particular field of law unless the state itself recognized that sort of, provided that sort of certification. For example, some states, I know Florida is one of them, have board certifications where you can become board certified in a particular field of law. California is another board certification state. So you can be certified and hold yourself out as being certified if you were in one of those states that allows for such certification. But unless you are, the general rule was that you couldn't hold yourself out as being certified. There were also rules that developed about the names of the law firms themselves. And interestingly, the rules evolved to say that, well, you may use trade names. And this was a very interesting aspect that developed early on. Law firm names historically were people's names. And the idea was you needed to have a real lawyer who was affiliated with the law firm. They needed to be there. Their name needed to be in the firm name, because otherwise we would have difficulty finding these people. And it was important for notice provisions and for the public to be able to find the lawyers, to have the lawyer's name in the title of the law firm. But this didn't really work out so well, because what happened when you branded your law firm in the founding partner's name and that founding partner died? Well, they're not going to be found anymore at that law firm, and yet their legacy could still continue on. And so many states then would draw in exceptions to those rules that would allow for deceased founding partners, deceased name partners to still have their names remain. And there are various other cutaways or exceptions drawn to the trade names, but many states still required lawyer names to be in the firm's names. And some states, even to this day, prohibit law firms from using trade names as a law firm name because of the belief, as such as it is, that a trade name is going to be inherently deceptive because the general public won't be able to find the lawyers who are behind the trade name. So now what's going on? Those were rules that were passed in the mid-1980s. The Patent Office eventually got on board with those rules, and it passed ethics rules. State bars came along and followed the ABA's rules as well on attorney advertising. And so throughout the 80s and 90s and 2000s, all of the state bars basically latched on to the ABA's proposed model rules on attorney advertising. And those have been lasting since the mid-1980s. But what's going on now in the last couple of decades, especially the last decade? We are in a technology revolution, and this has come to pass in how lawyers themselves are delivering legal services and advertising and soliciting clients, because there are now ways of reaching clients that the ABA and regulators in the 1980s couldn't even fathom possibly existed. That could even be possibilities for anyone to use. So the old rules, the ones that were passed in the mid-1980s and which state bars eventually latched onto, doing away with the former no advertising at all to some level of advertising, those old rules were really based on traditional advertising. Traditional advertising being the sense of newspapers, television, radio. Then you have your bus stops and all of those other types of modes, but not like we have now. Now we have online ratings. Now we have match services. Now we have blogs. Now we have websites. Now we have social networks. Now we have all of these new technology tools that are not just how lawyers connect with clients, but how clients find lawyers. Clients aren't looking in newspapers anymore to find lawyers. They're going on their phone. They're going on the internet. They're looking for those resources that aren't those traditional means of media and how lawyers traditionally communicated with clients about their services. One thing you also have to understand about change when it comes to the ethics rules and change when it comes to technology. The change when it comes to technology comes very, very fast, and it's completely out of our control. Things have moved so fast in the last 20 years. I don't have to tell anybody who's on this platform. This platform didn't exist 10 years ago. We didn't have this means for communicating with one another. It wasn't even a concept. So how quickly have things changed now? And yet the ethics rules, they change slow. So we're in 2021, and people are getting their information in a way that they didn't get it 30 years ago. And this has created has created much consternation amongst the bar about how do we apply these quote unquote old ethics rules that are really were developed in the mid 1980s based upon how lawyers practiced in the mid 1980s and how the public got information about lawyers in the mid 1980s. How do we evolve this to the way lawyers are working today? This was and is a huge undertaking. We'll give you an example about how kind of silly, or not silly, but just how literal the old ethics rules would be in applying them in today's, in using some of the tools that we use today to market ourselves. So let's look at a very simple example. I'm sure many of you are LinkedIn, and probably some of you have these skills and expertise areas, and your friends check your boxes and say how great you are at certain things. Some bars find that to be an impermissible form of advertising. Some bars have said that, these LinkedIn skills and expertise, those could be forms of misleading advertising, because unless you're board certified, for you to hold yourself out as having skill and expertise in a particular area is potentially misleading, unless that person is board certified. Shocker, Florida is a board certification state. So Florida wants to be relevant for its people who are board certified. Other jurisdictions have said that, well, they could permit certain endorsements and testimonials and recommendations, provided that there's some sort of a disclaimer that you add to it. That's like, this is attorney advertising, or past results aren't a guarantee of future success, or something, just putting something on that. But those sorts of things don't really necessarily apply in the way that people are getting information in 2021. People are really people really looking at the LinkedIn skills and expertise and are being affirmatively misled by someone simply because, someone checked a box they've said that says they're really good at trademark law. They're really good at patent law. Somebody writes up a nice review on them, says this person is the best at whatever it is that they do. Some state jurisdictions find that to be problematic. And so what has happened beginning really in the mid 2010s, right around 2013 and 2014, an Association of Professional Responsibility Lawyers. It's a think tank of the best ethics lawyers in the United States, the specialists in the field, several hundred who are committed to legal ethics as their real main practice area of law. And the association, APRL, has some of the leading thought leaders in ethics. These are people who were involved in the 1980s in the development of the ethics rules in the 1980s. So they were particularly persuasive in comparing why the rules were what they were in the 1980s, how things have changed in the mid 2000s, 2015, and why there is this disconnect between the old advertising rules and the new way that we're doing business. What the APRL did was they published a very persuasive report in 2015 that made a very compelling and persuasive argument as to the need for the bars around the United States to update their advertising and marketing rules so that they come into the 2000s and really the internet age. And so the idea was to simplify the ethics rules and to get rid of some of these overly paternalistic requirements that had to do with trade names and law firm names and putting disclaimers and fine print and some of the nitty-gritty little seem to be overkill details in terms of how you're supposed to advertise, or that you've got to put certain language in. And the idea what the APRL was envisioning and what the American Bar Association adopted was a fundamental shift that occurred in 2018, which really focused on maintaining the existing structure for false and misleading communications, so that lawyers are still prevented from false or misleading claims. It still adds the prohibition about live person-to-person solicitations. But other than that, it adds to both of the rules significant latitude for lawyers to solicit more and to use the internet more without having all of these necessarily cumbersome, and sometimes they don't really work so well, disclaimer language, outside of the envelope language. You'll still see bars requiring disclaimers, but those disclaimers don't really fit very well on a website, and they don't have the same impact as you would on a mailed letter that says advertising material on it, because lawyers pretty much today don't mail letters to prospective clients anymore. That just doesn't happen anymore. So in 2018, the American Bar Association proposed changes to its model rules to simplify the rules on advertising and solicitations, to focus on, number one, let's keep this simple. Let's keep it focused on no misleading communications, no false or misleading communications. Let's expand the right for lawyers and recognize that lawyers can communicate through various means, not just through traditional media, but other forms of media. And let's expand the provision on solicitation to add that you can solicit other lawyers, former clients, business associates, friends, families, as well as And here's a big category: persons known to be experienced users of the types of legal services involved. That's a pretty significant shift from what existed before, where no solicitation was involved at all. So if you have an educated prospective client that you believe needs your legal services, under the ABA's new model rules, that they would allow a direct solicitation to that experienced user for the type of legal services involved. And remember, I said these rules change very slow. This was a rule change in 2018. That was not a rule change made by any state court or federal tribunal. It was just the American Bar Association, which has model rules of professional conduct. And so every state now is looking at their own version of model rules and saying, hey, look, the ABA updated their model rules. Maybe we should update ours too. And so slowly but surely, the states are grabbing onto the ABA's version of the model rules changes. The USPTO updated their advertising and solicitation model rules just recently, at the end of the end of this year. So several years after the ABA model rules were proposed, many states are just now beginning the process of modifying their advertising and solicitation rules to come into the same sort of model that the ABA model rules are. Eventually, they will all get there. It's a slow process. The important takeaway for anyone who is on this call is that you cannot ignore your state's present bar rules for advertising and solicitation just because the ABA has updated its model rules. Many legacy rules still exist on a state-by-state basis, and unless and until those states update and change their rules on advertising and solicitation, you need to make sure that you're cognizant of the rules that govern where you practice to see where your state is on this continuum, or have they taken steps to update their rules on attorney advertising and ethics. Many of again, what I mentioned before, the new model rules deleted the old rules that talked about communications of field of practices and specialization, deleted all of these old rules about firm names and letterheads, but those are just the model rules. The states haven't all come on board yet. They are slowly coming on board one by one, but it could take years for all of the states to come on board to develop some modification of their rules. So you need to be mindful of that. So we're going to switch up a little bit and getting away from where this historical background of ethics rules themselves have played out and get you into something a little bit more really, how are people getting to solicit clients in 2021? And there's several different ways that just didn't exist 10, 15, 20 years ago. One is the matchmaker service. There are attorney-client match services. You heard earlier on the trademarks in the trademark presentation earlier about platforms being Amazon as a platform for selling trademark goods on, or eBay being a platform. This is a different kind of a platform where I'm talking about here. What we're talking about here are services that help bring together buyers of legal services and sellers of legal services. And these can be very specific or they can be very general. I'm not going to identify any of these platforms specifically by name, but there are a number of them that have continued to evolve over the course of the last several years. But they fundamentally operate as a meeting place for lawyers to advertise their services, to identify potential new client opportunities, as well as for potential clients to vet and screen advertising and to vet and screen possible lawyers. In one of these particular models, lawyers sign up and they get screened and they join to be able to provide legal services to members of an online community who also join and solicit legal services. The customer, or the potential client in this case, might issue a request for proposal that gets passed along through a platform that is run, and whoever, it could be a lawyers that are in a particular jurisdiction. Let's say a client request for proposal is, I need a California lawyer to help me with a trademark issue, trademark registration. And so on the platform side, there will be lawyers who are identified by their jurisdiction, and there will be lawyers who are identified by their practice areas. And when you find those matches where you have, hey, I'm a California lawyer and I'm also doing trademarks, and maybe there's some other filters as well. And what that results in is that the request for proposal might get issued to a number of different lawyers who all have a shot at the client and who could all provide a solicitation to the client saying, hey, I see that you reached out looking for legal services. Here's what we offer to do. And it's a very interesting way for clients to connect with lawyers, particularly when they don't know any lawyers and they don't know how to find any lawyers. Some people could look at it as a real win-win. For lawyers, it provides flexibility. It helps them with getting gig work. It helps solo practitioners find other clients who might not be ginormous clients, but might also have particular needs. For clients, it gives them information. It gives them competition. It gives them selection. It gives them access to justice, which is a societal benefit that the bar likes to discuss a lot. But attorneys have to be very careful when they're discussing these match type services, because even though these match services are existing and they can provide real value for new clients and for lawyers as well, lawyers have to be very careful on how those types of platforms operate. In particular, they have to make sure that they are not sharing legal fees with the platform, because that's still an ethical no-no. Some of these platforms are monetized based upon a formula that could be tied to the amount of the lawyer's fees. So some of these match services may not be ethically compliant from a fee-sharing standpoint. Lawyers also have to be sure that if they are sharing information with clients over these third-party platforms, that those platforms are secure, that confidential information can flow to the client and through to the lawyer without having a platform operator, web host, get access to confidential legal advice that could be passed through these types of platforms. Lawyers have the obligation to protect their clients' property and money. And the only way they're really going to be able to exercise all of these ethical duties when using their platform, these types of matching platforms, is they really have to get under the hood and understand how these platforms actually operate.
Okay, real quick, Mike.
Sure.
Going to interrupt you for just a moment. It is CLE code time, so get out your paper, pencil to record the code. The code is 5 ethics 9, has the number 5, the word ethics, the number 9. All right, there it is. Please continue, Mike.
So when we're looking at these matchmaker platform type issues, some of the things you're going to look at is, okay, if the client is paying the entity, a platform, a middleman, for the lawyer's fee, and then the platform takes a cut, that could raise issues of fee splitting. It could raise issue of referral fees. Who holds onto the client's money could raise issue about the lawyer's responsibilities to hold client funds in trust. If a client pays you for legal services before you've provided those services, many state bar rules require lawyers to hold that money in a trust account. because it hasn't been earned yet. But what happens when the money is going to a third party and that money hasn't been earned yet? Is the third party holding that money in a trust account? And if not, is that a problem? Those are issues that need to be considered through the various permutations of how each one of these types of platforms operates. And it's a very case by case, platform by platform specific analysis to review how they actually operate, to really decide if they're ethically cutting the mustard and doing things right. Another serious concern that has arisen that's an offshoot of technology, and also plays into how lawyers and legal professionals are getting clients, has to deal with the unauthorized practice of law. What technology has done is help create universes of entities or things, software programs, for example, that can replace or supplement functions that lawyers do themselves, sometimes even replacing the lawyer. Now, remember, we talked about this eternal battle between the bar and lawyers. On the one hand, the bar wants to regulate the legal profession to protect the public. But on the other hand, the bar is regulating the legal industry to protect the legal industry from outside competition. And that rub still exists with online advertising and online solicitation. Lawyers need to be particularly careful who they are doing business with so that they don't get caught up in an unauthorized practice of law situation. When I speak about this in this context, I'm not just talking about fake lawyers and fake law firms, like someone who's not a lawyer and not a law firm. What I am talking about is actually, it could be a software platform that is actually so good that is actually creating legal documents and becoming a thing that supplements or replaces the lawyer actually engaging in the practice of law. Or what's even more common, and this is very common in the trademark and patent space, are non-law firms that are offering legal services, either in this country or outside of this country, but to clients or prospective clients in this country, as well as for lawyers on this country to get those clients and to engage through those types of services, a middleman type relationship, so that you can earn legal fees by going through yet another middleman. This could be a potential problem for the lawyers who get involved with these middleman organizations, because if the middleman is engaged in the unauthorized practice of law, the lawyer themselves could get in trouble for aiding and abetting the unauthorized practice of law to the extent they help and aid and assist an entity that isn't allowed to practice law to do so. And so this has happened in many different ways in the IP space. Some of the more recent examples have been patent agents who represent applicants in trademark matters before the USPTO. Patent agents are not allowed to represent trademark applicants before the USPTO. And so by advertising and offering their services to do trademark legal work, they are engaging in the unauthorized practice of law. That's a problem. In the In Re Shia case, Shia was a patent agent who also provided trademark legal services. That ultimately ended up with Shia getting disbarred from practicing before the Patent and Trademark Office in any matters, not just the patent matters she was allowed to, but also the trademark matters in which she wasn't allowed to. Most important thing is for lawyers to understand is that when they are working with non-legal entities that are helping them deliver legal services, they have to be supervised. The lawyers have to play a role in making sure that the non-practitioners themselves are properly supervised. If the lawyer is supervising them properly, then the non-practitioner can be just like a secretary, just like a paralegal, just like anyone else you would have in your own house or in your own law firm who aids and helps the lawyer to do their legal services. But the key is lawyers' supervision. And a lot of times, these types of marketing act operations that allow lawyers to get business through third-party intermediaries, the lawyers aren't actually doing the supervision. It's something that needs to be something that lawyers have to be mindful of. And this takes us through to intermediaries and middlemen of a very particular specific variety that I'm sure that many IP professionals are familiar with. And that deals with foreign clients who deal with foreign associates. In patent and trademark practice, it has been customary. I've been practicing patent law for almost 30 years now. And when I started out, I was practicing with patent lawyers who had been practicing law for 50 years. And so going back, I've gotten a lot of historical information about how patent and trademark work has evolved from overseas markets and has come into the United States, and how U.S. lawyers have evolved in their own practices to be able to reach out and get foreign clients to trust them and deliver to them clients so that they can then perform legal services. Back in the 60s and the 1970s, there were law firms that literally would have to go to the foreign countries, meet face-to-face with foreign associates, establish relationships with foreign associates, because the only way you were going to get a foreign client in a typical patent prosecution or trademark prosecution matter was to have local counsel in the foreign country, which was going to be the intermediary. That particular model of IP lawyers getting business referred to them through foreign associates has been part of the culture of IP law for decades. It hasn't changed. It's not going away. It's okay for lawyers to get business through foreign associates and other types of interfaces, but they just need to make sure they've got to be mindful of several key aspects of the relationship again, because what's going on whenever you have a foreign associate or an intermediary, or even whether it's a software platform, it's the idea is the same, that there's someone or something that stands between you as the lawyer and your end client. Whether that middle thing is a foreign associate, foreign law firm, or if that middle thing is some sort of a legal services platform that's a matchmaker, or that's just a website. It is something that is doing, that is that can it is between you and your client. You need to be cognizant of the fact that when there is someone between you and your client, you've got to be knowledgeable about some of the ways that the PTO has looked at this in the past. Going back in our history lesson back into the 1980s, when the USPTO first decided to get on board and have its own code of professional conduct, the idea of this affecting foreign associates was very much a big concern, because many U.S. lawyers were getting business from foreign associates. And when the USPTO first came out with its own code of ethics that had all of these restrictions, that included restrictions that seemed to interfere with their ability to do business overseas, lawyers in the U.S. complained, and that caused the USPTO to issue guidance that basically said that U.S. attorneys can get business from foreign associates, but they have a duty to ensure that their foreign clients are aware that they are, in fact, being represented by the U.S. counsel, and that the U.S. counsel is working through the foreign associate. And as long as the foreign client is aware and consents to the U.S. attorney getting business from the foreign associate and assisting the client working through the foreign associate, as long as the client gives informed consent that that's okay, then that is a perfectly acceptable way for U.S. counsel to get business, continue to get business, solicit business, market their services, advertised. It's through the foreign associates and the foreign associate law firms. It's not so much a concern about the outbound marketing that where the foreign associate issues come in. It is that on the inbound side, is the lawyer taking care of their clients, or are they deferring too much on whatever is the middleman that's telling them what to do? A practitioner, according to the USPTO, a practitioner is entitled to rely upon the instructions of and accept compensation from a foreign agent, a foreign associate, a corporate liaison, a middleman, as long as the attorney knows that the owner or the applicant has consented to doing business this way, based upon making some sort of disclosure to the client that allows them to, again, to service the client through this middleman. As long as one is doing those things and is doing things in accordance with communicating with their foreign associates so that the clients understand that they are being represented by U.S. counsel, it will help to alleviate many of the concerns that the USPTO has expressed most recently with regard to the foreign counsel issue. This, by the way, has become more of a hot button issue in light of the, particularly in regards to trademark practices coming from overseas markets, and particularly what led to the foreign counsel rule, where there's been a lot of fraudulent or suspect trademark applications coming from overseas markets. Many of those have come from outside entities that appear to be law firms or maybe foreign associates, but they may not necessarily be real foreign associates or real intermediaries. And yet U.S. attorneys are being solicited by the foreigners themselves to be able to do business for their foreign clients. In some respects, some of these outside legal providers from foreign countries are actually trying to get U.S. counsel to essentially loan them their filing credentials and paying them a per application or a very small nominal fee to allow foreign applicants to get around the U.S. counsel rule so that they can continue to be able to apply at a very low cost, below real U.S. market costs for trademark legal services, as an end run to the U.S. counsel rule. The USPTO is having none of that. They are looking very hard at U.S. counsel who are getting business, marketing and soliciting clients that are coming from overseas markets, and particularly in the trademark space, particularly with large volume filers who have maybe questionable cases of usage, questionable cases of legitimate bona fide use in commerce, and are really coming down on the U.S. attorneys who are accepting these referrals for not doing enough to vet these foreign intermediaries, to ensure that the foreign intermediaries are themselves legitimate enterprises who are themselves legitimately explaining what the U.S. rules are to their own clients, so that authentic, genuine trademarks are being applied for. So that is a huge issue, and this is going to be an ongoing issue of concern for until the USPTO has made some fundamental changes in how its U.S. trademark register is being maintained, and some of the issues that we've heard about with regards to the other efforts being done by the USPTO to clean up the register of bad marks that were never being used in commerce. A lot of those stemmed from initially the fact that U.S. attorneys were being solicited by foreign middlemen to provide trademark services to to foreign clients, and the acceptance of those types of that type of a situation has caused a lot of headaches, and is going to be causing a lot of headaches for people who end up becoming my clients, or who may in the future become my clients. And there's been a lot of disciplinary actions going on now at the U.S. Patent and Trademark Office. So just to wrap up, because I know we're kind of running out now and we're on a tight schedule, I want to make sure just a couple of takeaways. Make sure that even though we're in a situation where model rules are being changed for advertising and solicitation, always pay attention to what's going on in your own local jurisdiction, because there's changes that are happening on a daily basis. States are changing their rules. Use client engagement letters as much as you can. It will help define your client. It will help deal with some of these issues, particularly when you're involving middlemen, platforms, intermediaries, and anytime you've got somebody that's operating in between you and your client. You've got to make sure you are cognizant of what agreements are controlling the relationship, so that no one gets between you and your client who's basically has the ability to interfere with your exercise of independent professional judgment.
I'm actually going to advance that one more because I want everybody to have your contact information readily available. So you can scan that code there to add Mike as a contact on your phone. All right. Thank you so very much, Mike, for this presentation. It was incredibly enlightening. And I think it's all stuff that we really needed to know. So we want to make sure that we're on the right side of the law always. So up next, we have a social event, a networking event. We would like to have you come join us for our escape room adventure, which has been sponsored by McCabe Ali. I don't know if I'm supposed to say this, but I made this connection, right? So Mike, we can pretend I didn't say it if it's not ethical. But okay, so if you're in trouble and you're trying to escape it, who do you call? You call McCabe Ali. Anyway, I thought it was a perfect thing for them to sponsor. Um, but anyway,
I like that very much.
you
That's a
like that?
really
You
good.
like that? Okay.
Yeah.
All right. So speaking of awkward situations that I need to escape from, this is one of them. Come and join us at, so you'll need to go back to the schedule tab and find this networking session to get that link. And I will see you there. This one is in Zoom. I do believe. So follow the link and I will see you there in about 3 minutes. So take a quick bio break if you need one. I will see you at 6 o'clock Eastern time. Thank you so much. Thanks, Mike, for this great presentation. And
Thank
thank you
you.
all for joining us.